Okay, class. So now we will start on the formal topics, which is the law on obligations and contracts. First, we will start on law on obligation. So we will start in Article 1156. Okay, so here we have the definition of a what is an obligation. So as you can see in the model that I've given you, there is an definition there in Article 1156, which is an obligation, is a juridical necessity to give, to do, or not to do. Okay, so to elaborate it more, I we have this definition by Arias Ramos. Um, it is more complete rather than the Civil Code's provision. It is defined as a juridical relation whereby a person, which is called the creditor, may demand from another called which is the debtor, the observance of a determinate conduct, and in case of breach may obtain satisfaction from the assets of the latter. So the kinds of obligation, as we can observe in the definition, we have two kinds. Um, First, actually in the civil code, we have two kinds according to juridical quality. So when we say juridical quality, it inter it pertains to the juridical nature of the obligation. So can it be enforced to the court, or can it not be enforced to the court? So first we have natural, then second we have the civil. So what is provided here in Article 1156 is the civil obligation. Okay, so in natural obligation, I will discuss first the natural obligation. This is in Article 1423, and the examples of this are in Article 1424 and 1430. So let's say, for example, and to exemplify the natural obligation, let's say a certain debt, okay, a certain utang, nag-prescribe na siya. So when we say prescribe, kasi we have this provisions before the obligations and contracts. Um, 1106, Article 1106, it talks about the prescription. So actually a prescription extinguishes and creates rights. So let's say an oral contract, there was an oral contract of debt. It will prescribe in 4 years. It means, class, na kung wala nimo siya gisingil, you did not demand sa utang sa imong receivable for 4 years if you are the creditor, then if you would file a case for the collection of the money, then your filing is beyond already for the 4 years of where the debt was when the debt was contracted. Then dili na siya ma-enforce. It becomes a natural obligation and not a civil obligation. Okay, so that example where a collection of sum of money has already lapsed. So according to law, when it is oral, then it is 4 years. When it is written naman, it is 10 years. So despite the lapse of the period, kunwari si debtor, nag-voluntary siya bayad without acknowledging the existence of the debt. So, biska nag-lapse na ang period, okay, so si debtor katong nangutang, nagbayad gyapon siya even if he knows na nag-lapse na ang period. So, in this case, the debtor, he voluntarily pays. So, dili na niya ma-demand back tungod kay nga na si debtor, oops, wala ko kabalo nga, let's say, wala ko kabalo nga nag-lapse na ang period. Wala ko kabalo nga, na prescription rules. So, can I demand back? Dili, pwede naman ta dili bayaran because na ang nag na beyond 4 years na siya. So, under the natural obligation, the debtor cannot demand katong nangutang what he has paid back. Okay? As a natural obligation, it authorizes the creditor to have the right of retention. So, nanay right of retention si creditor karon to what has been delivered to him. Okay? But in the civil obligations naman, the difference lang between civil and natural obligations, 'di ba, we have discussed um, the what is a positive law, 'di ba? The positive law is a statute law, okay? So it is already provided, expressly provided in our public policy. So natural obligation is not being based on positive law, but it is on equity and natural law. Okay, civil obligations, it gives you a right of action to compel their performance. Kasi in the um, in the earlier mentioned na example, what if si debtor wala niya na within the 4 years, let's say si creditor rather, within 4 years na nag-file siya action for collection of sum of money, then it is a civil obligation because he has the right of action to compel the performance. And what is that performance? The payment of debt of the debtor. Okay, so that's a difference between natural and civil obligation. Okay, so what is being referred in Article 1156 is the civil obligation. So what are the essential requisites of an obligation? Again, when we say essential requisites, so these are the most important elements. Okay, elements are requisites. Okay, so when we say requisites, it becomes a component of of the subject matter, in this case, the obligation. Okay? So, kung mawala ang isa ka-element, it does not become an obligation or it is an invalid obligation or void. Okay? So, as if there is no obligation at the first place. So, first, we have the subject. Second, we have the object. And third, we have the juridical or legal type. Okay? So, first, let's discuss about the subject. So, it could either be active subject and passive subject. Okay? So, the active subject, siya karon ang mo demand for the fulfillment of the obligation. Why it is okay, later na lang. When we say passive subject naman, it is against whom the obligation is juridically demandable. So when we say active subject, it is the creditor or the obligee. Okay? So si creditor mo ni ang nagpautang, while si passive subject is or the debtor of the obligor mo ni siya ang nangutang. So sir, um why is it that the creditor becomes the active subject? Okay, what is the act upon it? Okay, nga naging active subject siya. So, basically, siya manggod ang mo demand for the payment. Siya karon ang kusang upon the contract, let's say in a contract of debt, 'di ba? So, na-deliver ang money and all. So, after that, siya karon ang mo demand for the fulfillment of the obligation. So the act there is to demand the fulfillment of the obligation. That is why si creditor karon ang nagiging active. While sa passive naman is wala may buhaton, kung dili mo demand si creditor, pwede naman po dili bayaran ni debtor, di ba? So that is why he is called the passive subject. So next is what is the consequences? So these are the elements, no? So we are already here. So what is the consequences of limitations of person's capacity to act, to enter into contract? Okay, so we have this, baka you will be misguided that all obligations are contracts. Okay, so not all obligations are contracts. Contracts is just a one source of an obligation. So these limitations are understood in relation to capacity to enter into a contract. So we will also dwell this in the later topics when we enter the contract. So let's say for example, the fact nga insane ang tao, it will not prejudice the creation of an obligation from another source. So it is a source other than the contract. So let's say another example, if one of the parties to a contract is a minor, so the contract there is not invalid. Okay, it is not void. It is just merely voidable. But let's say if that minor, why it is voidable? Because the consent there, which is one of the elements of the contract, becomes only defective. There is a consent. Kaso nga lang, it becomes defective because of the incapacity of the person. Okay, so the contract there is voidable, not invalid in the first place. But if the minor kills another person, he is not automatically exempted from liability from acts or omission punished by law or liability arising from quasi-delict just merely because that he is a minor. So he cannot argue the the contention that he is a minor, therefore he does not have any obligation because such act is voidable. Okay? So diyan siya pwede. Okay? Next is the prestation or the object. Okay? So, when we say prestation or object, this is the juridical to give, to do, or not to do. Again, in case analysis, when there is an example na, if there is a construction of house, then if you would be asked what is the object in this case, that is not the house, okay? It is the construction of the house because it is a to do. Sir, nga na ay to give, na to do or not to do, but walay not to give because the not to give merely is already included in the not to do. To give actually is also a, in essence, actually is a to do because to give connotes also the delivery of an object, okay, or of the subject matter. Okay, next is what are the requisites, okay? So, paano ba nabay times nga ang object, dili siya object, okay? So, kailangan nato tanaw ng requisites of an object, okay? So, one of the requisites of an object is that it must be legal, okay? So it must be possible in fact and in law. And also it must be determinate or at least determinable, and at least it has a pecuniary value. Okay, so we will also dwell on that later, but just an introduction to you. Okay, next is the efficient cause. Okay, the efficient cause, it may um, or the vinculum juris or the juridical die. Actually, these are the sources of obligation, which I think would be discussed on Article 1157 or 1158. Okay? So, these are the sources. Ano ka nagkaroon ng obligation? Because tungod sa law, tungod sa contract, tungod sa quasi-contract, delicts or quasi-delicts. Okay, next. It is also important to note that what is a real obligation and personal obligation. So an obligation to give is a real obligation, and to do and not to do is an personal obligation. Okay, obligation to give. That's why it must be determinate thing, and in the term determinate thing, di ba, one of the requisites that it must be determinate, or if it is indeterminate, it can be determinable. Okay, so obligation to give is a delivery of a thing. Okay, so it could either be specific or generic, which we will discuss that also later. So this is just an overview, class app. Next is personal obligation. So we have to do and not to do. So this is the positive and this is the negative um, personal obligation. So it involves a kind of work or services, whether physical or mental. Okay. Um, so I will just discuss again the I will just discuss the determinate and determinate na lang in order to cover it. Okay. So what is a determinate thing? So a determinate thing, actually it can be it is specifically designated, while the indeterminate thing, it is not specifically designated or segregated from all other class. But some of the authors in your book or in the other books, they introduce the concept of limited generic thing, where generic objects become also a specific object, where generic objects classified according to a particular class. Okay, so a determinate thing is introduced to us in Article 1460, which is outside the ambit of our subject. Okay, so what is a determinate thing? So a thing is determinate when it is, according to Article 1460, a thing is determinate when it is particularly designated or physically segregated from all other of the same class. So example of this is like a car which has a plate number of, let's say, 1463. So we can say that it is determinate because it is physically designated from the rest, okay? But when you say indeterminate, it cannot be designated, or it has not been segregated. Uh, it was not segregated from other class. Okay, so it's example on the 2010 car. Even if you put a red color into it, or even if you specify that it has four wheels, tinted red, it was tinted as red. Ano pa ba ang mga customized? Because it still becomes a indeterminate or generic, because there you can find another kind of car just like that. Okay, so what makes the prior example where there was a plate number unique or indeterminate? It's because of its plate number, because plate number is not cannot be identical to others. Okay, so that's why do we need to distinguish the two? Because a generic thing never perishes. Okay, so so much for that. Let's proceed to article. Okay, I will just discuss muna the kinds of obligation. I have already discussed this. So the moral obligation is based on conscience. I have already discussed this, and I have already discussed this. Positive and negative. So unilateral naman is it is one party bound to perform obligation. Okay, so just like donation, diba? The obligation is on the part of only to the donor. So the donor will just accept the donation. In the family code naman, to give support. So who are the people who is bound for support? This is the husband and wife, the father and the mother. When okay, so that is a unilateral obligation, because only one party is bound to perform. Okay, when we say bilateral naman, two parties are reciprocally bound for each other. So in a contract of sale, di ba? Both the buyer and the seller have the obligations. In the part of the buyer, the delivery of the money, while on the part of the seller, the delivery of the object. Okay? So in the lease naman, where in the lessor the has the obligation to rent out the the property, while the lessee will pay the rental fee. Okay, so now here we have the Article 1157. So what are the sources of Article 117? I think it had jumped, no? So in the sources of Article 117 is we have actually five. Obligations arises from law, contracts, quasi-contracts, acts or missions punishable by law, and quasi-delict. So actually, this is not stated in your book, but if there are some other sources other than that provided under this Article 1157, any injury that will arise therefrom is not actionable, because only these are sources are recognized by law. So now we will go to Article 1158. So actually, this is the fourth and the fifth. I'm sorry kung wala siya na-appeal sa ako presentation, but first is the law. So under Article 1158, obligations derived from law are not presumed. Okay, so you need to read the Article 1158. Okay, so it is very specific that these obligations arise from the positive law, because positive law are never presumed. So the obligations from law are not presumed. Okay, when you say are not presumed, class, there is no presumption. Okay, so like the right to support, since um kunwari kung let's say namatay ang mother and father, then walay siblings, would it be presumed nga dito dayon diretso sa auntie rather than the lola? Or let's say na lang namatay ang mother and father, then the sister, there was a sister that is working and beyond 21 years old, would it be presumed nga dito sa auntie mangayo og support rather than dito sa ate na who is already working. So when you say to exemplify what is presumption is that the presumption according to law falls to the ate rather than to the ante. Okay, so this kind of obligations, these are not presumed. It must really be stated in law. Okay, so if the law does not provide for such obligation, then that obligation does not exist legally. Okay, so there are some commentaries actually on the books that would say that the enumeration under Article 1157 is actually misleading because in truth, the actual basis of obligations are only contracts and law. Why? Because the fact that a new civil code has already recognized the law, then other sources of obligations may be subsumed under the category of law, like quasi-contracts, acts, or omissions punished by law, and quasi-delicts. But nevertheless, you already know Article 1157. Okay, so how do we determine that an obligation actually arises from law or some other source? So first, it must be noted that in the birth of an obligation, so when you say birth of an obligation where all the elements concur, um, there there must always be a concurrence between the law na nag-establish an obligation and the condition upon which the obligation is based or predicated. Okay, so but if the law merely recognizes the existence of an obligation generated by an act which may constitute a contract, quasi-contract, or delict, quasi-delict, so the law's only purpose is to regulate such obligation. Then we say that it is the act itself is the source of obligation and not the law. Okay, so actually you can read that on Jurado's book. Okay, so what are the examples of obligation arising from law? So first we have Article 36 of the Family Code. So um, in the psychological incapacity, also we have the Article 68 to 71 of the Family Code. We have the marital obligations, and also beyond that Family Code, we have the right for support, 'di ba, sa mga descendants. So that is also under the family code. Other other ano pa ba? Other like in commerce in our business laws. So division of profit, the right to distribute the profits. So that is in accordance to the civil code and the law and partnership. Um, the right the obligation to pay taxes under National Internal Revenue Code. So you already I think you already know that one because nakatax one naman kayo. So also the right to pay taxes which is customs duties, 'di ba? And tariffs. So that is under the customs code. So um also, let's go back to the family code. If those obligations that are to be observed in marriage, let's say, are not provided under the family code, then let's say the obligation itself does not exist because there are no acts or conditions upon which we can predicate or base the obligation on. So, in essence or in summary, there will always be a basis for an obligation arising from law. Okay, next is obligations arising from contracts. Okay, so Article 1159 talks about the obligations arising from contract. Okay, so the contract also to introduce again, daan na lang, what is a contract? We define contract in accordance to Article 1305. So Article 1305 states that a contract is a contract is a meeting of minds between two persons whereby one binds himself with respect to the other to give something or to render some service. So, in this article, we are introduced to us, it what is being introduced here is that the characteristics of the obligations arising from contracts. Kasi actually, we have the three characteristics. Okay, so we will learn this in our midterms that the three characteristics are the obligatory force of the contract, um, relativity, and also the mutuality of the contract. So here we are introduced one of the component of obligatory force is the principle of autonomy of will. This is what is being stated, and also this is one of the cases that I actually have assigned to you. So it is provided in 1159 in the principle of autonomy of will, the concept of compliance in good faith. Okay, so actually compliance in good faith, it does not substantially preclude substantial compliance. So what the law requires lang is that mo-comply ka in good faith, especially in cases sa mga contracts. So not necessarily a literal or clear observance of the only stipulations of the contract, but you have to comply or oblige yourself in accordance sa stipulations, sa conditions, sa terms, sa mga provisions, clauses provided dito sa contract na to. Okay, there these are the matters nga kailangan nato i-consider in order to know if ang mga obligations have been complied in good faith. So however, kung ang parties in an agreement, it is the civil code ang mag-regulate sa manner nga paano nila ma-carry out ang obligations, because if the contract is valid, we need to honor the contract. So it is important that apart from the understanding the contract itself, it is required that we learn how the law regulates contracts. So it is deemed implied that the law is included in each and every contract. Okay? So remember, even if it is a contract and has the force of law between the contracting parties, contracts still have to abide with the provisions of law. That's why contract shall be invalid unless it shall be invalid if it is contrary to law, morals, good customs, public order, or public policy. Okay, so one of the laws that regulates contracts in general is actually the new civil code that we are talking about right now. So from the definition of the contract, take note na to ang phraseology of the law na a contract is a meeting of the minds. So in each and every contract, one of the essential requisites is actually the existence nga na ay consent, okay, between the contracting parties. And when do you know that there is consent? When there are at least um two persons involved, and these persons are what we call as contracting parties. So contracts with consent, um and have no observation or any formality are deemed I I'm sorry, contracts with consent pero let's say if there is no observation of any formality, 'di ba I have discussed to you earlier, let's say the donation, there are formalities in order for it to be valid. So one of it is a donation of the real property. In order for it to be valid, kailangan naka-public instrument siya. But what if it is a donation of a personal property, let's say donation of car? So um, what the law requires, if it is beyond 5,000, then it must be in writing in order for it to be valid. But what if, sir, gusto sa contracting parties na ipa-public instrument, ipa-notarize siya. Okay, so that is still valid. Okay, so it is only for the convenience of the contracting parties, and we will go to that in the form of contracts on midterm. So, but the point here is that the contract is still with consent, even if there is no observance or formality nga even you require, not for validity, okay, but for enforceability to the courts. These are still valid contracts. Example, or the contract, oral contracts like contract of sale, it need not to be in writing because it is consensual in nature. Okay, so even if a in contract of sale in real property class, okay, the deed of sale does not invalidate the contract of sale. Kung the non-existence of deed of sale rather does not invalidate the contract of sale. So kung walay deed of sale, you cannot say nga walay contract of sale because contract of sale is merely a contract of sale is merely a formality. Contract of sale is a consensual contract, and the deed of sale is merely a formality. Okay, example of that is in the case of Uy versus heirs of Uy. Okay, so na dito gihabiling gibaligya sa lola dito sa iyang apo ang yuta niya, but it later found out that the Supreme Court found out that it was in fact really a donation, but it was um it was raised by uh, the com- responded that there was no valid contract of sale because the petitioner was, if there would be a valid of sale, the petitioner would it would be he would be prejudiced to the effect of the contract of sale. So nga na si Supreme Court nga no, there was no even if we assume that there was no deed of sale, but still there is still a contract of sale because deed of sale does not presuppose the existence of a contract of sale. Okay? So, yun ang also in the case of Ainsa versus Padua, so this is just an additional also it supports the case of Uy versus heirs of Uy. Okay? So, again, sa autonomy of will, the contracting parties are presumed under the law to be on equal level or equal footing when they enter into a contract. So, when the Supreme Court manggod sees that the parties in a contract are not in equal footing or heavily weighs in favor of only one of the contracting party, it is violative to the principle. Why? Because it is only the will of um, one of the contracting parties that dictates the terms and stipulations in a contract. So, perfect example of this is the United Alloy versus UCPB na case. Okay? So, take note, during a case, there was a loan in this case. So, who are the sureties? Who are the guarantors? So that how do you distinguish sureties from guarantors? And the primary issue here, siguro this is just a hint to the person who will recite the United Alloy versus UCPB, whether or not the United Alloy failed to pay their obligation to UCPB, whether what did United Alloy breach that the Supreme Court held them liable. Okay, did the UCPB made a judicial demand? Okay, so what is the issue also in relation to the interest rates? Okay, so we will discuss that on during recitation. Okay, next is obligations arising from quasi-contract. So basically, what is a quasi-contract and what are the governing laws on quasi-contract? So um, I think this was also given to you in your book that um, under Article 1160, obligations are derived from quasi-contracts shall be subject to the provisions of still of the chapter 1 of this book, which is the Civil Code. Okay, but how do we define a quasi-contract? So, the basic elements is that a quasi-contract must be lawful, voluntary, and unilateral acts. Again, lawful, voluntary, and unilateral acts. So therefore, it must not be unlawful. It must not be involuntary, and it must not be bilateral. Okay? So, um, ang quasi-delit manggod, where there is a lawful, voluntary, and unilateral act na magbunga gud siya in a it would give rise to a juridical relation because under the principle that no one shall be unjustly enriched at the expense of another. Okay, so that is the main principle that um, we need to remember under quasi-delic. So remember the mnemonic na LUV because these are the elements of a quasi-delic. It must be lawful, unilateral, and voluntary. So what distinguishes a quasi-contract from an ordinary contract? Okay, so 'di ba we discussed earlier what is a contract? Then what is the difference of a quasi-contract to the contract? So it is the absence of consent, 'di ba? Because a contract has the essential requisites of consent, object, and cause. While in quasi-contract, again, 'di ba, kay voluntary man siya, unilateral man siya, therefore there was no consent at the first place. Okay, so there was this case in the Perez versus Pumar. The Supreme Court noted that a quasi-contract, um, there must be no express consent given by one party in favor of the other. So the consent needed in a contract is provided by law through a presumption or presumptive contract. So there are two types of quasi-contract. We have negotiorum hestio and the solutio indebiti. So how do we define negotiorum hestio? So a negotiorum hestio is defined under Article 2144. So um, actually it is a voluntary management. So for me, I just make it into a Bisaya because the length of its definition is so taas. So I just make it nga karang nakialam good ka when you pakialam when there is a management of a business or property of another nga wala kay authority at the first place but you obliged to continue the same. So requisites mong good ani is that the property was not neglected, okay, or abandoned. So then the manager was, if in fact the manager has been, um, I actually I'm sorry, um, negotiatum hesio would occur if if it is not if the property is neglected or abandoned and there was no authority on the gestator or the manager. Okay, so it would not occur pag wala gi-abandon, ay if gi-abandon rather, or um, ah, wala gi-abandon o wala gi-neglect. Okay, tama din. So wala gi-abandon o wala gi-neglect, then there would be no negotiarum hestio. So it needs to be abandoned and neglected. Then also, there was assigned manager. So basically, dili mag-occur ang negotiarum hestio because there would be a voluntary manager or gestator. So, in negotiarum hestio, we are introduced to a situation na where a gestator is actually obliged under the law to observe a certain conduct in favor of the owner of a property. So, example na ay dalawa ka bundok. So, it is graced by animals. So, one bundok is owned, let's say, by A and the other was by B. So, by sheer luck, it was only the mountain of B that was hit by rainstorm. So, since kay si B is away, there is no one to fend for the animals of B. So si A, gi-allow niyang animals of B to go over his bundok. So as a result, the animals grazed on the bundok of A. So A now is called the involuntary manager or the gestator. So again, this is a quasi-contract because there was an official's management. So even if there was no consent between the B that between from B that A would manage his animals, if A will voluntarily assume a liability under the law, so the juridical relation will give rise to an obligation on the part of A. So, kung mubalik na karon si B, then he must basically reimburse, di ba? A, if A has already incurred certain expenses in taking care of B's animals. Otherwise, B will be unjustly enriched at the expense of another. So again, we need to stick to the principle nga pag dili bayaran ni B si A, then magiging unjustly enriched siya, dawat siya benefit at the expense of A. Okay? This is the last, okay, this is the second one, the solution in DBT. So I actually call this payment by mistake. So under Article 2154, so this is a, if something is received when there is no right to demand it and it was unduly delivered through mistake, then the obligation to deliver it arises. So in this payment by mistake, take note that there was something received where um, where in fact there was no obligation, no contract, or no juridical relation was set or existed, whereby that person who received the thing may able to demand it. So example is like nagsakay ka o tricycle, then upon pagbaba nimo nagbayad ka og ₱10 and it was only, let's say, set in that city nga ₱8 ang minimum or the standard payment fare for the student. So pero nasuklian ka og ₱5, 'di ba? So basically there was a payment by mistake on the part of the driver na nasobraan. So ₱3 ang sobra. So you have the obligation. Okay, so this is still a source of obligation. So as ang obligation dito, you have the obligation to return the ₱3 because it is in excess or it is sobra sa iyang nadawat. Okay, example, nakadawat ka og Lazada nga delivery where in fact dili na mao imong gi-deliver, diba? You have the duty to deliver it back to or to return it to the Lazada company. Okay, so discussion next session we will discuss the fourth and the fifth. So again, please read the provisions. It is in the internet. It is also it is in the codal that I have sent to you. So please read that one and also in the PowerPoints. Okay.